Bankruptcy Small Businesses, Bankruptcy Options for Small Businesses Introduction. The press has reported that certain big pharma have considered bankruptcy as part of negotiations to reach a settlement over their liability in the opioid crisis. Bankruptcy, or bankruptcy restructuring, is not just for big companies. There are bankruptcy small businesses too. Earlier this year, Insys Therapeutics Incorporated in the United States ended up being the first opioid drug maker to use the bankruptcy statute. It followed its $225 million settlement with the federal government. In recent months, there's been a supposition that drug makers might utilize insolvency laws as a means to run away from accountability. That is not how bankruptcy protection works. Thankfully, that's not how bankruptcy works. Instead, as I've learned in my experience in the Canadian bankruptcy space, insolvency procedures are developed to not only help debtors. It likewise assists creditors too. Bankruptcy restructuring proceedings are not best for every stakeholder every time. The end result always appears unreasonable to creditors because they are not being paid in full. However, it's most definitely not the free ride for the company filing under the bankruptcy laws that many people think it will be. What happens when a small business files for bankruptcy? To many people, the thought of bankruptcy creates an adverse reaction. The reason is simple: a bankruptcy filing means there is not enough money to pay everyone 100 cents on the dollar. But the system makes the best of a grim situation by imposing an organized and open process that preserves value and urges negotiation. Bankruptcy reorganizations by well-known brand names such as General Motors revealed that it can bring parties to the table to reach agreements that could not be made absent the structured reorganization laws. It also resurrects sick businesses. At the most basic level, the Bankruptcy and Insolvency Act, Canada, BIA, and the Companies Creditors Arrangement Act, CCAA, develops for the estate to value and account for every one of the debtor's assets into one proceeding. Recognize and classify creditor claims against the debtor. In bankruptcy liquidation, sell the assets and distribute the money in priority of the claims of the creditors, and for a bankruptcy restructuring, to take a hard look at productive assets and those no longer needed, value them, allow for selling off redundant assets to allow the company to continue in its healthy business side and offer the creditors a better deal than they would get in a liquidation. Specifically, how those essential parts of the bankruptcy and insolvency legislation play out in a specific situation will differ depending upon what kind of insolvency filing the borrower makes and the specific truths regarding the conduct of the debtor. What types of bankruptcy can small businesses file? When we hear about bankruptcy small businesses, we normally think of a liquidation. However, debtors have two choices under the BIA: liquidation or reorganization. Pure bankruptcy liquidation is designed to sell off the assets either as a whole to one buyer to allow for someone else to carry on the company's business, or just sell pieces to many individual buyers. In the latter case, it means that business will not exist anymore. The value obtained from the asset sales will be distributed to the creditors in priority. First to statutory trust claimants, then to secured creditors, if any. If anything is left after that, it will then be distributed to unsecured creditors, first preferred unsecured and then ordinary unsecured. On the other hand, a filing under the proposal provisions of Part 3 of the BIA allows for the company to attempt to reorganize. All aspects of the business will be looked at. The debtor can sell some of its assets that are underperforming or no longer fit into the restructured business plan. The cash raised can be used in the reorganization strategy that aims to resolve the current business problems and allow the company to come out of bankruptcy protection as a new and profitable viable business. The BIA restructuring provisions are what would be used for bankruptcy small businesses. Large businesses, defined in this case as companies that owe more than $5 million, could use the same BIA proposal provisions. Alternatively, those large companies could also use the CISA statute to reorganize. The specific situation will dictate what legislation is used for a reorganization. Advantages of an insolvency process for debtors. Bankruptcy provides at the very least two valuable advantages to all debtors: time and room to maneuver. The minute a debtor files, an automatic stay is in play for the debtor. It operates as a timeout button on any litigation, collection or enforcement activities. Creditors can ask the court to lift the stay under specific conditions. However, the standard for doing so is typically tough to satisfy. The bankruptcy court has broad authority to regulate all issues involving the debtor's estate, including adjudicating any disputed claims. By uniting all those with a stake in the business's assets in one place, a debtor can effectively handle all claims against it. While the stay is in place, Debtors use the insolvency process to review their troubles and make the essential adjustments to prosper after reorganizing. Decisions are made about which contracts they want to carry forward and which to abandon. To stay clear of a disputed process, smart debtors use the insolvency restructuring process to reach a total overall negotiation and agreement with all stakeholders. If necessary, smart debtors will also offer a benefit to top up its restructuring plan to make sure that it gets the number of creditors necessary for the plan to succeed. Benefits of the insolvency process for creditors. Clearly, bankruptcy supplies debtors with substantial power to reposition their business affairs. What lots of people misunderstand, nonetheless, is that this power is balanced by solid creditor benefits too. The BIA calls for debtors to disclose considerable information about their operations and imposes stringent checks on their actions. As an example, the company wishing to reorganize must openly disclose financial and other information concerning every one of its assets. Much further disclosure is under oath in the sworn statement of affairs. There is also, if necessary, the ability to examine company officials under oath. In many cases, the debtor must seek the court's approval before taking actions beyond running the business operations in the normal course. Under the bankruptcy small businesses BIA provisions, the company is allowed to stay in possession of its property. Management also remains in control to continue running the business. The trustee must report any material adverse change. The trustee will also report to the creditors as part of the restructuring process. Creditors that are worried concerning the debtor's capacity to maintain the estate's worth might ask the court to expand the trustee's powers. It is possible to have the trustee also appointed as an interim receiver to control the receipts and disbursements of the company. Creditors can also ask the court to end the restructuring and place the company into bankruptcy. Creditors would need to show that either a key secured creditor or a large enough group of unsecured creditors will under no circumstances vote in favor of any restructuring. The insolvency laws allow for the creation of a board of unsecured creditors to oversee the restructuring. The court might also form a unique board standing for a major group of litigants in situations where the debtor faces lawsuits or claimants whose damages are not yet quantified. These and various other attributes include a degree of justness to an inherently unfair situation. The debtor might think that it is driving the bus, however, countless other stakeholders have the power to make sure that the business complies with the rules of the road. With such safeguards in place, creditors and the general public need not be afraid of the most awful possible outcome if bankruptcy provisions are used to try to restructure companies involved in bitter disputes. The playing field will never be even, but the Canadian insolvency statutes try to bring as much fairness into the system as possible.